Hey everyone, Kate Miller here coming to you on my latest Zoom. I am joined by Miller Bowles Cushing's newest attorney, Mollie Ellis. Hey Mollie.
Hey, Kate.
Hi. All right, Miss Mollie. We have a lot of cases that came out of the Court of Appeals this last month, and the one that I really wanted to get your insight on is the McKenzie case that deals with civil contempt. So, what can you tell us about what the Court of Appeals did with this McKenzie case?
Okay, yes. So husband and wife had entered into an equitable distribution order in 2016. Basically, in that order, husband had vowed to pay $236,000 from one of his accounts. That money was supposed to come from that account. He was going to pay it to wife with a certified check, and he never paid. So there was a 2017 hearing on civil contempt where the judge found that he was in civil contempt, ordered him to pay the amount that was in the account at the time, not noting how much was in the account at the time, but they also never held him in, never made the requirement that he was imprisoned until he paid. So of course he never paid. So then in 2019, there was another hearing and husband was again held in civil contempt. He was only required to pay the approximately $236,000 from the 2016 order, and he was told that he was going to be imprisoned unless he paid that money. So this time, he was obviously going to follow what the judge said.
It got serious.
Yes, now that he was going to be imprisoned, it was a little more serious. So then wife moved the court for husband to actually have to pay the amount that was in the account at the time, which at this point it had grown in passive gains to around $280,000. And also she moved for attorney's fees and for Rule 11 sanctions, and she was denied all of that basically. So she appealed, and on appeal, she asked the court to, as part of husband's purge condition, to have husband pay the entire amount of the account, because basically it had been sitting there with passive gains amounting to $280,000, and for husband to have to pay attorney's fees and Rule 11 sanctions, basically just because she had to file all of these suits and keep bringing them to court to finally get them to pay. So the Court of Appeals basically agreed with the trial court in saying that because the 2016 equitable distribution order between the two had only required husband to pay the approximately $236,000 rather than the full amount in the account, and not even to close the account, he was going to pay a check to her going out of the account on $236,000, that did not require him to pay the whatever amount was in the account at that time, probably around $280,000, but a certain amount, not any passive gains. And she kind of argued that because the 2017 contempt hearing had held him to pay the entire amount, that she wanted that to stick. And they said that basically now that there had not been the question of imprisonment then, and now because there was the threat of imprisonment, they were able to look at that purge condition anew, and that now they were going to go back to the 2016 order, ignore that the full amount would be owed in the 2017 order, and just stick with the $236,000 amount. As far as the Rule 11 sanctions, the Court of Appeals just basically said she didn't show enough evidence with the trial court to show what he had done for those Rule 11 sanctions, and so they were, remanding that down. And then with attorney's fees, they agreed with the trial court because they said that she did not provide the amount of fees that she wanted from him. Basically, she had not showed, probably like not an attorney's fee affidavit, is my guess, but she just hadn't showed them the actual number that was owed that she had paid her attorney to kind of defend her and getting her money in all these contempt hearings. So.
Well, sounds like a nightmare. Moral of the story is follow the orders, right?
Yes. Pay up.
And you won't find yourself in, years of litigation and then appellate cases and et cetera, et cetera. So what a mess. All right. Mollie, thank you so much for your insight today. I appreciate it. And we'll be checking back with you next time we have another fun Court of Appeals case to talk about. Thanks, Mollie.
All right, great. Thank you, Kate.
Bye.